Lesson: Historical Evolution of Contract Law. Contract law, a cornerstone of modern legal systems, has undergone significant evolution, shaping the way agreements are made, interpreted, and enforced. This lesson delves into the historical evolution of contract law, emphasizing actionable insights, practical tools, and frameworks that professionals can implement directly in their practice. By examining the transformation of contract law, from its ancient origins to contemporary applications, we can better understand its current principles and anticipate future developments. The genesis of contract law can be traced back to ancient civilizations, where informal agreements were primarily based on mutual trust and oral promises. In ancient Rome, the concept of pacta sunt servanda, meaning agreements must be kept, laid the groundwork for modern contract principles. Roman law introduced formalities such as stipulatio, a verbal contract characterized by a question and answer format, which required specific language and witnessed exchanges to ensure validity. This early framework emphasized the importance of formality and intention, principles that continue to underpin contract law today. As societies evolved, so did the complexity of commercial transactions, necessitating a more structured approach to contracts. The Middle Ages saw the rise of the lex mercatoria, or law merchant, a body of commercial law developed by merchants across Europe. The law merchant introduced concepts such as negotiability and the use of written instruments, which provided greater security and predictability in trade. This period marked a significant shift towards the recognition of contracts as enforceable agreements, laying the foundation for modern contract law. The principles of lex mercatoria were later absorbed into national legal systems, influencing the development of contract law in countries such as England and France. The 19th century marked a pivotal moment in the evolution of contract law, characterized by the rise of classical contract theory. Classical contract theory, rooted in the philosophy of laissez-faire economics, emphasized freedom of contract, allowing parties to negotiate terms without interference from the state. This era saw the codification of contract law, with landmark statutes such as the English Sale of Goods Act of 1893 and the French Civil Code of 1804. The emphasis on individual autonomy and the sanctity of contract during this period underscored the importance of mutual consent and the binding nature of agreements. However, the rigid application of classical contract principles often led to unjust outcomes, particularly in cases where one party held significantly more bargaining power. The 20th century witnessed a shift towards a more equitable approach, with courts increasingly willing to intervene and modify contracts to ensure fairness. This evolution was influenced by the advent of consumer protection laws and the recognition of implied terms, which sought to protect weaker parties in contractual relationships. The Uniform Commercial Code in the United States exemplifies this shift, providing a standardized framework that balances the interests of both parties while ensuring contractual obligations are fulfilled. In the contemporary era, contract law continues to evolve in response to technological advancements and globalization. The digital age has introduced new challenges, such as electronic contracts and digital signatures, necessitating adaptations in legal frameworks to accommodate these innovations. Tools like the electronic signatures in Global and National Commerce Act in the United States and the European Union's eIDAS regulation provide legal recognition and enforceability of electronic contracts, ensuring they hold the same validity as traditional paper agreements. These developments highlight the need for contract law professionals to stay abreast of technological changes and understand their implications on contractual obligations. To address real-world challenges and enhance proficiency in contract law, professionals can employ practical tools and frameworks that facilitate effective contract management. One such tool is the Contract Lifecycle Management software, which streamlines the process of drafting, negotiating, and managing contracts. CLM software provides a centralized platform for tracking contract performance, ensuring compliance with legal requirements, and minimizing risks associated with contract breaches. By leveraging technology, legal professionals can enhance efficiency and reduce the likelihood of disputes, ultimately improving client satisfaction and business outcomes. Additionally, adopting a risk management framework is crucial for identifying and mitigating potential contractual risks. This involves conducting thorough due diligence, assessing the financial stability and reputation of contracting parties, and incorporating clauses that address potential contingencies. For example, force majeure clauses, which excuse parties from performing contractual obligations due to unforeseen events, have gained prominence in light of the global COVID-19 pandemic. By proactively addressing risks, professionals can safeguard their clients' interests and prevent costly litigation. Case studies further illustrate the practical application of contract law principles and tools. The landmark case of Carlyle v. Carbolic Smokeball Co. exemplifies the enforceability of unilateral contracts where an offer can be accepted by performing a specific act. In this case, the court upheld the plaintiff's claim for a reward promised by the defendant, emphasizing the importance of clear terms and the intention to create legal obligations. This precedent underscores the need for precision in contract drafting and the potential consequences of vague or ambiguous language. Statistics also provide valuable insights into the significance of contract law in modern business environments. According to a survey conducted by the International Association for Contract and Commercial Management, poor contract management practices can result in financial losses of up to 9.2% of a company's annual revenue. This statistic highlights the critical role of effective contract management in mitigating risks and maximizing business value. By investing in training and adopting best practices, organizations can enhance their contractual capabilities and achieve better outcomes. In conclusion, the historical evolution of contract law reflects a continuous adaptation to societal needs, technological advancements, and economic realities. From its ancient origins to the digital age, contract law has transformed to accommodate the complexities of modern commerce while ensuring fairness and predictability in contractual relationships. By understanding this evolution and employing practical tools and frameworks, professionals can navigate the dynamic landscape of contract law with confidence, delivering value to their clients and contributing to the broader legal community. As contract law continues to evolve, staying informed and adaptable will be essential for success in this ever-changing field.